Hello everyone, welcome to my online prep. Today we'll start with chapter 15, that is Industrial Relations Part A. In this chapter, we have to learn about the personnel function, legal aspects of the personnel function, then we will study about the different acts in the legislation on working conditions, Industrial Relations Code 2020, legislations on wages, social security, employment and training. Also, we will see the changing scenario in today's time. So let us start with the first topic of today's session. So this chapter is about industrial relations. If we talk about the history of business environment, it was mostly stable. The customers were passive, the demand patterns were on a continuous basis, the technology was just adequate, no major demands were there on the business. But now there's a shift, the demanding customers, there's a shift in the power to the east. Transformation is seen in the human element from the union protected job security to a more individualistic approach. So the business environment has changed with the birth of the concept of global village, the expectations of not only the customers but also the employees. It has led to a more dynamic environment, a more individualistic approach. Now, with this, certain difficulties and challenges have also risen. Managing and retaining talent is a key challenge. Then there are three fronts for addressing the challenges. The managers, they focus on how they can create a more conducive environment that is going to retain the employees for a long period of time, then implementing systems for potential development, training, skilling, and establishing a reward and recognition mechanism. So the changes that have been seen, communication has shifted to the bottom up approaches. Now the hierarchy that was followed in the traditional systems, it has changed. Communication flows from the bottom up, from feedback as well. So the employees' needs and concerns have taken place. HRM has transitioned from controlling people to developing both employees and the organization. A more developmental, humanistic approach is being followed. Some traditional industries like the public sector banks, they have strong union influence in negotiations today. There are the bilateral settlements between IBA and the trade unions. They have demonstrated the continued power of collective bargaining and union influence. So these are some of the factors that have changed the scenario of business environment. Herein, one important managerial function is the personnel management. Let us see what is the concept. So personnel management, management of the people of an organization, it is the function of planning, organizing, directing, controlling, and coordinating the line functions or the operative functions. Line functions are recruitment, development, compensation, integration, utilization, and maintenance of people, so that the individual objectives as well as the goals of the organization, they can be achieved all together. So this is personal management, how we can manage the people, the line functions. Herein, it has evolved into the HRM, and it has three major spheres, that is strategic, professional, as well as administrative. So it deals with the aspect of relationship among the people, and it's also concerned about the well-being, not only as individual but also when they're working in groups or as teams, so that they can give their best. So there are these three functions that have gained more emphasis in the HRM function. These again get bifurcated into the welfare aspect that relates to safety, health, amenities, and facilities. And also there is the personal aspect. It relates to the recruitment, development, compensation, incentives, the settlement of industrial disputes, etc. So it is divided into these two. Welfare related to the personal, and the personnel that relates to the various line functions. Also, HRM today is concerned with the maintenance of high degree of employee morale and satisfaction. We have studied in the previous chapters how motivation is important. It is a determining factor of how well the people are going to perform their task. So all of these things are important. We have understood the meaning of personal management. Let us also see some of the functions that are performed. So basically, there are three categories of the functions of personnel management. These are the strategic functions, professional functions, and administrative functions. Strategic functions are related to the strategy. What is the mission or vision of the organization, goals, business goals, how the strategy formulation takes place, organization life cycle stage, competency identification. It also includes competency mapping and analysis of the competition. Then we have the professional functions. It is related to the performance management and review mechanism, the key result areas that have to be focused on, what are the key performance indicators, the key deliverables, also the benchmark on which the performance is compared, employee morale and superior performance, the relation to the achievement of goals. And third is the administrative functions. This is related to the functions performed by the management or administration, like recruitment and selection of employees, performance and potential evaluation, training and development, compensation structure, how reward and recognition can be used, employee retention, career and succession planning is important, and employee wellness and welfare. So these are the functions that are involved in the personnel management. Next, we have the legal aspects of personal function. Now, although the organization or the business have the freedom to decide their own policy, they can frame their own guidelines, but still they are the citizens of the nation. So the laws that are prepared for all of the citizens will also apply to the various labor or employees in the organization. So here we have stated the important laws in India which apply to organization. These come under five categories: the legislations on working conditions, on wages, social security, employment and training, and industrial relations. We'll be discussing further in this chapter various acts like the Factories Act, Mines Act, Payment of Wages Act. All of these that are mentioned in the table, we'll be discussing about them. Also important is the chronology. We need to remember the year in which the act came and it is being applied. The various objectives, functions, features, we'll be discussing about them. All these enactments or laws, they are related to certain objectives of the rights of the working class. First is to protect and safeguard the interest and well-being so that the employers, they cannot exploit them, to regulate and improve the working conditions, and to provide for fixation and payment of minimum wages so that the task or responsibilities that they are assigned, they are being compensated enough or equally for that, to ensure timely payment of wages and avoid unauthorized deduction from the wages, to spell out and notify the service conditions for the information of all the concerned so that the people, workers, they know about their rights, then to provide formation of trade unions, how trade unions can promote collective bargaining. They are concerned with the wellness and interest of the workers. If workers they face exploitation, they can go to the trade union, to arrange for social security measures like in the event of sickness, disablement, and death of workmen, so they can get compensation, rest, and leaves, to promote industrial peace by providing for machinery so that industrial disputes can be settled, to be receptive to the market demands and legislations for the facilitation of modern businesses, and to promote the ease of doing business, reducing the compliance burdens, modernizing the legal framework surrounding the regulation of industrial relations in India. So the different enactments, they have objectives, their own features. Still, the broad objectives that are common to all of them, they remain the same. Basically, they govern the interest and well-being of the working class. Now, we'll be seeing some of the important enactments for the working class. First, we have the category of legislation on the working conditions. In this, the Contract Labor Regulation and Abolition Act 1970 is of importance. This act provides for the abolition of contract labor and where possible regulation of the contract labor. So contract labor, for their wellness, for the abolition, here this act works. What are the features and main provisions? The act is applicable to every establishment in which 20 or more workmen are there. They are employed as the contract labor. They are working on a certain contract. Also, that is applicable to any contractor who employs or had employed on any day 20 or more workers, then the act is, however, not applicable to the establishments that are working only on the casual basis, right? So contract has to be there. Workman here is deemed to be a person employed as a contract labor when hired through a contractor with or without knowledge of the principal employer. If they're employed on a contract basis, they'll be stated as a workman. Every principal employer of the establishment to which act as implies must get the establishment registered under the act. If they are employing contract labor, they must have a license under the act for executing the work through the contract labor. So getting registration and license is important. Then the appropriate government may prohibit any establishment for employing contract labor. They need to consider whether the conditions of work and benefit provided are satisfactory. They should not be underpaid. Working conditions should be good. Whether the work is incidental to or necessary to the business of the establishment. Whether the work is of a perennial nature or of sufficient duration. Whether it is ordinarily done through regular workmen. So these are the conditions. If the government, if the regulatory body is satisfied of the conditions and the reasons for the contract, then only the license will be provided to the employer. In this situation, some of the facilities that the contractor is required to provide is they should provide a canteen. If the establishment employs 100 or more workers, restroom should be there. If the contract labor is required to be there at night, sufficient supply of drinking water and washing facilities, first aid box. If the contractor fails to provide these facilities, then it is the responsibility of the principal employer, the owner of the institution. They have to provide these facilities. They should be there if they are using the contract. Then the payment of wages shall be made by the contractor in accordance with the provisions of the Payment of Wages Act 1936. We'll be discussing about this act in the further slides. It is the responsibility of the principal employer here to pay the unpaid wages if the contractor fails to pay. If we talk about then a notification of December 6, 1976, the central government has prohibited employment of contract labor by banks for sweeping, dusting and watching of buildings. So banks, they cannot employ contract labor for these purposes. Today, outsourcing is used. It is not only a means to reduce cost, but also it has come to signify a major improvement in the quality of services. So major banks, public sector banks, these are ISO certified, hallmark of quality operations, they're using outsourcing. So RBI has, for some reasons, they has allowed the non-core activities of banks. They have clearly spelled out where outsourcing is allowed in the banking institution. Second act under the working conditions is the Bombay Shops and Establishment Act of 1948. That is for the regulation of conditions of work and employment in shops, establishments, hotels, restaurants, etc. So it is applied for a shop or establishment that has to be registered under the act with a local authority, and the license is valid for 1 year. It has to be renewed on timely basis. Herein, no employee should be asked to work more than 9 hours on any day and 48 hours a week. These provisions are there. If extra work are given, then compensation according to that should be provided. It also provides for rest intervals for weekly holidays, not more than 5 hours before having an interval. At least one interval has to be provided. The Act also makes provision for leave. Even if the employee quits employment, he has to be paid for such leave if the application was rejected earlier. So these conditions for leaves are also provided. Provisions how the employee can take a leave. Act also requires the employer to maintain attendance register, leave record, etc. for the same purpose. Herein, different states have enacted similar legislation and are applicable to the shops and establishments. Banks have also been granted exception from many of the provisions under the state acts. These apply to the malls and other service sector, but not to the banks. So this is related to the various shops and establishments. Then we have the Trade Union Act of 1926. Objective is to provide for registration of trade unions and give the registered trade unions a legal status and immunity to their office bearers from the civil and criminal liability for pursuing legitimate union activity. So unions will be formed, they will be registered, and they will be given legal status. So enough power is given to the trade unions. Now herein what are the salient features? Trade dispute has been defined by the Act as any dispute between the employers and workmen, or between different workmen, between employers and employers. It is connected to the employment or non-employment, or the terms of employment or the conditions of workers. So dispute, when there is a disagreement between these parties. Workmen can be all the people who are employed in trade or industry with whom the trade dispute arises. Then trade union will mean a combination. It will be formed for regulating the relationships between the stated entities, workmen and employers, different workmen or different employers, for imposing the restrictive conditions on the conduct of any trade or businesses. So this relates to the trade union. How the trade union can be formed, what will be the powers and responsibilities, how it can be approached, registration of the trade union, the requirement, all of this comes under the Trade Union Act of 1926. Then we have the Industrial Disputes Act of 1947. Actually, this act has been consolidated and replaced along with other acts. We discussed about the Trade Union Act and the Industrial Employment Standing Orders Act of 1946, and now all of these they come under the Industrial Relations Code of 2020. We'll be discussing about this in the further slides. So it has been replaced, but still we need to study what were the main features. Objective of the act is to provide for investigation and settlement of industrial disputes that can occur between the employer and employer, workman and different workmen, employer and workmen. So the resolution of different disputes. Now the Supreme Court through various judgments has outlined the following objectives. First, to ensure social justice to the employers and the employees, and to bring about harmony in the organization, to settle the disputes through the conciliatory machinery, to provide them advices, to prevent illegal strikes and lockout that can affect the production, to provide compensation in workmen in case of layoff, retrenchment, closure, and to promote collective bargaining. It is a method of the resolution of disputes in which both the parties that are involved they can get certain benefit, so that a mutual understanding can be reached. Now appropriate government means for industry are carried out by the central government. Even state government in some cases they have given out their own laws, their own guidelines. So it is related to the disputes that can occur in the organization. So this act it applies on the public utility services like railway, postal, telegraph, telephone, or any area or department that the government seems fit. Then industry can mean any business, trade, undertaking, manufacturing. Again, the list is exhaustive. Workman means any person who is employed in the industry to do any work, any task that is appointed. Then, in an attempt to resolve the industrial dispute, the Act makes it obligatory to constitute a Works Committee. Works Committee has certain responsibilities in the industrial establishment. Committee consists of equal number of representatives of workmen and the employers. So, the constitution of conciliatory machinery with the conciliation officers. It is to be appointed on boards of conciliation to be constituted by the appropriate government. Conciliation is again a measure to resolve the dispute. Voluntary reference to arbitration, again mutual understanding, mutual discussion, so that a solution that is acceptable to both the parties can be reached. Also, it makes it obligatory for the employer to give a notice of any change before actually enacting the change. If there is a change in the strategy, conditions of the service, the respect of wages, hours of work, so it has to be provided at least 20 days before effecting the change. Act prohibits strikes and lockouts in the public utility services without giving duties. So proper notice has to be provided before going on strike or lockout. Also under certain conditions it is prohibited. The act provides for layoff, retrenchment, and closure. Again, for that, a specified procedure is to be followed, it is required to be followed, and the prescribed rate is to be paid to the workman that is affected. So, these are certain conditions or the features of the Industrial Disputes Act. Next, we have the Industrial Relations Code 2020. We discussed in the last slide that certain enactments have been subsumed. It is under the Industrial Relations Code. It is notified by the Government of India, and it is one of the four labor codes that forms a part of the central government's largest reform schemes. So it subsumes the important central laws that relate to industrial dispute settlement. These are the Industrial Dispute Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. The Industrial Dispute Act, which aims to provide workers with a mechanism, it will provide them relief against the layoffs, retrenchment, and wrongful dismissal. Trade Unions Act, to provide workers with better working conditions, wages, protection, also to provide them a fair share of the company's profits, and to realize their right to form an association for collective bargaining. And Industrial Employment Standing Orders Act, it relates to providing the standardized terms and conditions that is to be given to all the workmen in the particular establishment. So it subsumes, this code subsumes all of these important laws that were earlier existing. The objects of these acts have been retained for most part, still certain changes have been implemented. Let us see what are the salient features. In this code, the definition of worker that was earlier given has been expanded. Now it includes the working journalist as well, sales promotion employees, also supervisory employees that are earning less than a specified amount are also considered as workers under this code. The fixed term employment, it now has a legal basis. It ensures the benefits and equal treatment for the fixed term employees that are working in the organization for a particular time. They are eligible to receive tips on a pro rata basis as well. Then the Labor Relations Bill 2019, it has set the threshold for the Labor Disputes Regulation Act at 100 employees. But now the Relations Code of 2020, it has raised this threshold to 300 and also has allowed exemptions by the appropriate government. The section 65 of the code, it deals with the layoffs and reductions in the personnel for the industrial establishments that have more than 50 workers. Section 77 applies to the establishments that have at least 300 workers or a greater number that has been specified by the particular government. They require prior government permission for the layoffs, staff reduction, and closures. Also, the code prohibits strikes and immediate lockouts in all the companies. Strikes are restricted, proper time frame has been provided, permission and notice has to be given, including the 60 days before or after the strike notification, during mediation, and during the pending labor code proceedings. So these are some of the changes that have been introduced in the Industrial Relations Code. Now we will see separately the different areas which it deals with. First, we have the guidelines regarding trade unions. The new concept has been introduced as the negotiating union or the negotiating council. In this, if the industrial company has a single union, so it has to be recognized as the sole bargaining union for all the workers. The employer has to recognize this as the sole bargaining union. If, however, there are several unions, more than one are working, then the employer will recognize a bargaining union that has 51% of its employees. In case of several trade unions, none of which fulfill the 51% membership criteria, then the employer forms a negotiating council. If a single union does not have more than 51% members, then negotiating council concept will be used. It will be made up of the representatives of these registered trade unions who are supported by at least 20% of the total workforce. So herein the negotiating council will be made with the following representatives. Also, it provides that if the central or state government believes that there is a need for a union or confederation to be recognized as central or state union, then the government has to recognize all the trade unions alike. That is, they cannot discriminate. There's a central or state union, then all of them will be treated as equal. So this is regarding the trade union. Then second is related to the strikes and lockouts. So the code defines strike as including the concerted casual vacation on a given day of 50% or more. So if the workers in the industry, if among them 50% or more go on a vacation, then it will be stated as strike if they're not working on a particular day. No employee can strike without reporting a strike to the employer. They have to give a notice 14 days in advance, and this notification is valid for a maximum of 60 days. Without giving prior notice, strike cannot be done. Likewise, no employer can lock out one of its employees without giving a 14 days prior notice before the lockout. Again, this notification will be valid for 60 days. In addition, the Industrial Relations Code also prohibits strikes and lockouts in the case during and up to 7 days after arbitration, during and up to 60 days after or before trial in the court, and during any period in which the settlement or arbitration award is in effect. So in these cases, strike and lockout is prohibited, they are not allowed. Then the employers are also required to report to the relevant government and arbitration officer within 5 days of receiving or announcing a strike or lockout. So when they receive a notification or a notice, or they're giving out a notice for lockout, it is their responsibility to report it to the government and arbitration officer. Regarding standing orders, it has been stated that the provisions will apply to the establishments that have had 300 or more employees on any day in a year in the preceding 12 months or a year. If there are 300 or more employees, then the standing orders will be applied there. Second, an employee will be required to prepare a draft of the standing orders, which will be based on the central government model, and it has to be started within 6 months from the code start date in consultation with the recognized negotiating unions or members of the council concerning the matters that has to be certified by the officer. So the standing orders, a draft has to be created and followed. For the reskilling funds, so provision for the creation of a reskilling fund has been given for the employees that are laid off from the industrial establishment by the employer. So if an employee is being laid off, then skilling has to be provided. This provision is created. The fund which is to be created will be made up of the following amounts. Employer contribution will be there. It will be 15 days of salary as the last retirement of the workers, then contribution from the other sources as prescribed, and the fund must be used to pay at least the last 15 days of the salary that is extracted by the worker within 45 days of the layoff or the dismissal. So this is related to the reskilling funds of the laid off employees. Provisions related to the layoffs and retrenchments are also defined. Layoff is defined as the inability of an employer from giving employment to a worker. This can be due to shortage of any of the means of power, material, machinery, or a calamity. Then, if they are unable to provide employment further, it is known as layoff. Retrenchment, on the other hand, refers to the termination of service for the reason other than the disciplinary action. It does not include retirement or non-renewal or completion of tenure. Other than the disciplinary action, termination will be done. It is the retrenchment. The provisions on layoff and retrenchment under this code do not apply to the industrial establishments that have less than 50 workers on the average working day. So more than 50 workers is the eligibility criteria. Wherever a worker whose name is borne on the muster rolls of an industrial establishment, who have completed not less than 1 year of continuous service, whether continuously or intermittently, then they will be paid by the employer for all the days during which they have been laid off. So compensation will be provided, that is will be equal to 50% of the total basic wages and the dearness allowance that will be paid to the person that is being laid off. Further, for the factories, mines, and plantations that have 300 or more workers, they must take prior permission of the appropriate government before they make effective any layoff, retrenchment, or closure. So the employees, they get proper compensation in the case of layoff or retrenchment. This is covered under the Industrial Relations Code. And the last provision is related to the grievance redressal mechanism. It has been stated that any industrial establishment that has more than 20 employees, it is required for them to have at least one or more compliant redressal committees for the resolution of disputes that are arising from the individual complaints. The committee should be made up of an equal number of members that represent the employees, employer as well as the workers, and the chair should be elected from among employees and workers on a rotating basis each year. So equal opportunity, equal hearing is to be provided. The number of grievance redressal committees, however, cannot exceed 10, and there must be adequate representation of female workers as well, and must not be less than the proportion of the women that are employed in the establishment. So for the resolution of disputes or complaints of individuals, the grievance redressal mechanism should be established. So these are some of the important provisions that are covered under the Industrial Relations Code that subsumes the previous codes that were working. Next, we have the different legislations on wages, under which first is the Payment of Wages Act of 1936. Objective is to regulate the payment of wages at least once in a month and at regular interval. Also to prevent unauthorized deductions from the wages, so as to make sure that the workers, they are getting adequate wages on timely basis. No unauthorized deductions are there. This act works. There are certain features. The act can be made applicable by the state government by notification to the establishment. Herein, the act covers the employees whose wages are less than 24,000 per month. The term wages here includes any bonus that is given, contribution to the provident fund, pension fund, any gratuity that is payable. It will include all of these things. In organizations that are employing less than 1,000 persons, wages shall be paid before the expiry of the seventh day, and where more than 1,000 are there, then it has to be paid before the expiry of the ninth day of the month. The payment of wages is to be made in currency notes. On authorization from the employees, payment can also be made by check or credit in today's time to the employee's account, provided that appropriate government notification is there. Payment is to be made without any deductions except for those that are authorized by the act. Then also authorized deductions are there, the fines, absence, deduction for damage or loss. Apart from these, any unauthorized deductions can't be made. However, the Payment of Wages Act is not directly applicable to the banks. It is not directly, some parts of it are applicable. Second is the Minimum Wages Act of 1948. It aims to provide for fixing the minimum rates of wages in certain employments. Features are, it is applicable to the employments that are listed in the Part 1 and Part 2 of the Schedule to the Act. It covers establishments regardless of the number of workers that are employed, such as the rice mills, then flour mill, tobacco manufacturing, oil mill, etc. So establishments like these are covered. Wages will include the remuneration capable of being expressed in the terms of money that is paid to the person, but it will not include the value of accommodation that is provided, supply of light, water, and other amenities, contribution to the pension fund, etc. So what all has to be included has to be kept in mind. Where the appropriate government has fixed the minimum rates, the employer is bound to pay the rates, not less than. So it will tell the minimum rate that has to be paid, and anything less than that is not acceptable. The rates of wages can be fixed for different employment, classes of employment, different localities. There may be a time rate, a piece rate, guaranteed time rate, as well as overtime rate. It is to be prescribed. Any contract or agreement by an employee that is relinquishing his or her right under this act shall be null and void. Now the act has fixed floor levels for the wages. It will also be not applied to the banks as it is not treated in the scheduled employment. So the act does not apply to the banks. Next is the Payment of Bonus Act of 1965. It is providing for the payment of bonus to the persons that are employed in certain establishments on the basis of the profits or production or productivity that are related to the industry. So how bonus will be paid? The act applies to all the factories and establishments that are employing 20 or more persons. Bonus is payable to person whose salary or wages does not exceed rupees 21,000 per month and who have worked in the organization for not less than 30 days. Not disqualified to claim bonus due to fraud, theft or any misconduct, people have to be paid the bonus. Herein, the determination of gross profit is the first step towards calculating the amount of bonus that has to be paid. So gross profit is calculated, then the procedure is given in the act. A part of that gross profit or percentage, how it is to be distributed as the form of business or the bonus is to be done. It is an obligation on the employer to pay the bonus at a minimum rate of 8.33% of the salary or rupees 100, whatever will be higher, and the maximum rate is fixed at 20%. So the range is from 8 to 20%. Herein, the fourth schedule of the Act illustrates the method of set on and set off factor. The excess of the allocable surplus after distributing the bonus shall be the set on. So set on refers to the excess and the forward up to the fourth accounting year. In case there is shortage or there is a lack of allocable surplus, then it will come over the set off. So set off is the lack of allocable surplus. However, the new establishments, they get exemption from payment of bonus up to a period of 6 years. So payment of bonus comes under this act. And the last act under the legislation of wages is the Equal Remuneration Act of 1976. It provides for the payment of equal remuneration to men and women. That prevention of discrimination on the grounds of sex against women. If women are working on the same level as the men, they will be given equal wages. The remuneration includes basic salary and any additional emoluments that is payable in cash or in kind for the same work or the similar nature. No discrimination will be made while requiting the same work except where the employment of women is prohibited or restricted. No discrimination should be made against women in the matters of conditions of service, promotions, training, etc. And it is obligatory to maintain the prescribed registers and documents in relation to the employees. Now, this act, although may be applicable to the banks, since this aspect is taken care of in the industry level wage settlements. The burden of the compliance is not at individual bank except to comply with the provisions of the bipartite settlement. So it partially applies to the banking industry. So these are the different acts that are given under the legislation on wages. Next, we have the legislation on social security to provide the employees social security. First, we have the Employees Compensation Act of 1923. Objective: it imposes an obligation upon the employer to pay compensation to the workers for accidents that are arising out and in the course of employment. So if the employees, they face any accident or injury when they are working, when they are in the organization, then there's an obligation upon the employer to pay them compensation. The act applies to any person who is employed in the occupations that are specified in the schedule 2 of the act. Herein, the capacity in railways, factories, mines, these are included, and it is to be included in the definition of the workman under the section 2. Person that is employed, employment should not be of casual nature and he should be employed for the purpose of employer's business. So a particular nature of employment is to be considered. The compensation is payable for any personal injury that is sustained by the person in an accident arising out of and in the course of employment if they're working in the organization during that time. No compensation is payable if the disablement does not continue for more than 3 days. So there are different requirements in these act as well. What compensation should be paid, how much. Section 4 to 7 detail the rate at which compensation is payable for the different types of disablement. The usual criteria: higher the level of displacement, higher will be the compensation. For the fatal accidents, compensation would be the highest. Then there's a doctrine for notional extension. Herein, the Supreme Court has explained this doctrine. As a rule, employment does not commence until the workman has reached the place of employment and does not continue when he has left the place of employment. So, if the person is injured and they're not in the particular industry physically, then it will be treated as the leave and compensation will be paid for that until they are ready to join the work again. Second is the Employees Provident Fund and Miscellaneous Provisions Act of 1952. It deals to provide substantial security and monetary assistance to the employees and their families to protect them during old age, etc. Now, this has been replaced by the Employees Pension Scheme of 1995, and it provides for regular income after the retirement or death in the form of pension. Still, we need to see what are the features of this act as well. So, as per an amendment to the Provident Fund scheme from time to time, now the wage limit coverage has been enhanced to rupees 50,000 per month. This is with effect from 2014. It includes any person employed for wages in any kind of work in connection with the work of an establishment. So, this is the limit. The normal rate of contribution to the Provident Fund by the employees, it has been increased to 12% from 1997. So, it has been raised. Earlier, it was 8.33%, then revised to 10. Now it is 12. The term wages will include the basic pay that is given, dearness allowance, as well as the retaining allowance if any. The contribution received shall be invested after making payment on account of the advance against PF and withdrawal. It is according to the pattern that is laid down by the government under the scheme. A member may withdraw full amount from the PF account in the event of retirement from the service after attaining an age of 55 years. So there are options there: a retirement on the account of permanent incapacity, migration for permanent settlement abroad, termination in the course of mass retrenchment. Scheme also provides for transfer of the payments account, that is if the person is leaving the service of an employer. Refundable withdrawal is also there, and every member shall be supplied with the accounting statement immediately after the close of the accounting year. So this is regarding the protection under the Provident Fund scheme. Next, we have the Maternity Benefit Act of 1961 that deals with the welfare of working women. So it provides for leave and certain monetary and other benefits for the pregnant women. It applies to every establishment that have 10 or more employees. It can be a factory, mine, etc. Here, the maximum period of maternity leave is 26 weeks. It is divided before delivery and after delivery. Women are entitled for maternity leave. They must have worked for not less than 80 days in the preceding 12 months in the particular organization. In case of miscarriage, a woman is entitled to 6 weeks of leave for illness, out of delivery, premature birth, or miscarriage. Extra maximum period of 1 month leave can be there. That will be, and also if the work is of a nature that can be done from home, permission should be provided. No pregnant woman should be given any work which involves long hours of standing. A woman after resuming their duties is to be given at least 2 nursing breaks. Additionally, maternity benefit is also entitled to a medical bonus of rupees 250 if no prenatal or postnatal care has been provided by the employer. Now, from 2017, every establishment that have 50 or more employees, they shall be providing the facility of crèche as well within such distance that will be prescribed. Other common facilities also have to be provided. Benefits such as free medical aid, maternity bonus, provision for crèches, all of these are covered under this Act. The last act under the Social Security is Payment of Gratuity Act of 1972. So gratuity is a part of benefits that are paid to the employees after their retirement. So it comes under the retirement benefits that are paid to help the employee during this period. Objective, it provides for a scheme for compulsory payment of gratuity to the employees that are employed in factories, mines, shops, or any establishments that have 10 or more employees. So herein, the Amendment Act of 2017 has removed the salary ceiling of an employee. But the maximum gratuity that is paid, it has a ceiling that is rupees 20 lakh. Herein, the section 4, it confers a right on the employee that they shall receive gratuity if they have rendered continuous service of not less than 5 years on superannuation, retirement, or resignation. So if they have given 5 years service to an organization, continuous service, then they have the right to receive the gratuity. On their superannuation, retirement, resignation, or even death. On death, the family members will be paid the gratuity. Gratuity can also be forfeited if the services of the employee are terminated for any act of willful omission, negligence that causes damage or loss to the property of the employer. Section 6 provides for the nomination facility as well. Payment of gratuity is done on submission of an application form, and this act is not liable to be attached in execution of any decree or order of any civil, revenue, or criminal code. So the gratuity payable under this scheme of the banks or other employee can be attached to the extent that it exceeds one that is payable under the act. This is also there. So the Payment of Gratuity Act of 1972 deals with how much gratuity will be paid, what are the provisions, rules, and regulations. And the last legislation that is covered is on employment and training. In this, we have the Employment Exchanges Compulsory Notification of Vacancies Act 1959. So, this here the objective is to enable the government authorities to assess the employment potential and to have better appreciation of labor market, as well as to enable the unemployed persons to seek employment. So notification of the vacancies, how it will be posted so that better employees can be taken, they can be employed. Also the person who are unemployed, they can seek employment. For this, the act works. The employer is obliged to notify the vacancies in the organization before filling up any vacancy. The vacancy should be notified in writing to the employment exchange having jurisdiction over the area at least 15 days before they start the interviews, so that applications can be received, the applicants can know about the vacancy. So at least 15 days before the interviews, the notification has to be given. The employer is also required to submit quarterly and biennial returns to the employment exchange. It will give details regarding the total number of employees, vacancy positions, occupational classification of employees, and other related aspects. Now, while the employers are required to notify the vacancy, they are not obliged to appoint only those that are sponsored by the employment exchanges. They can consider, but it is not necessary that they employ only those. And the act does not apply to the vacancies that are filled through the promotion or the results of any examination that are conducted or interview by independent agency such as the union or state public commission and the like. So the notification is compulsory for various departments. Banks also come under them. So now we have discussed in brief some of the main provisions of certain important laws. We have studied the provisions of the Trade Unions Act, the Industrial Disputes Act. We will also study in detail in the further units. Now we will see what is the changing scenario or the current scenario. The current scenario is that there have been clear indications that the government is seriously considering, they're thinking about giving a revamp to the labor laws due to the concerns that they overly protect the workers. There has been a feeling that the labor laws, they tend to overprotect the workmen. Many cases they have resulted in indifferent attitudes, that even if they do not give the required amount of time and effort, they would be paid the compensation. This is adversely affecting their performance. This attitude has developed because of the termination of employment is now extremely difficult on the grounds of inefficiency. The difficulty of terminating employment, like we said, has contributed to this problem. Employees in the organized sector, they should also recognize that employees now treat them as partners in production and they respond accordingly. This has given changes in the management philosophies. Because of this, with the changes in the nature of management, they are treated as partners. So this should be seen favorably, respond in their own interest as well as the interest of the organization. A number of attempts have been made to amend the major provisions of these acts, but still India, they are still rigid in hiring and firing rules as compared to the other countries. In fact, if we talk about the, for example, the Industrial Relations Bill, which was to overcome the major items of both the Trade Union Act, they're making the laws even more rigid. Many of the labor laws, although have been amended, still a part remains, that is giving extra privileges to the working class. Also, it is not surprising that the labor data from the 80s show that number of people that employed in the firms were greater than 100 has gone down. Now, from all these, we can say labor law reform is seen as an essential part for the interest of the workers, but it requires proper debate, explanation, and complementary policies for ensuring their social security and welfare. The reforms should not completely change the nature, they should still consider the welfare of the workers. For example, privatization of certain public sector units may also impact the industrial relations in those sectors. So these decisions, if and when they are taken, they may completely change the industrial relations scenario in such sectors and industries. So the changing scenario in the labor front that have a direct impact on the union and their influence over the working class has to be given enough emphasis. With this, we have come to the end of this lesson. Keep learning with us. Thank you.